Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which is, Loretta, you can do it with me, the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautiful. Ladies and gentlemen, it's always constitutional heaven here at the National Constitution Center, but we're coming off of one of the most exciting weeks since I've been here, and that was Constitution Day, where 4,000 school kids gathered at the NCC on Thursday. Justice Breyer was here, and the head of the College Board and I announced the launch of the new Interactive Constitution, this really thrilling new educational tool that has united the best scholars in America, liberal and conservative and everywhere in between, to write about every clause of the Constitution, describing both what they agree about and what they disagree about. And the College Board announced that it's going to make this the center of the new AP History and Government exams, and that eventually we hope to bring it to every student in America from 8 to 80, because this is the only place where citizens across the country can find civil dialogue about the Constitution that doesn't shy away from disagreements, but also finds common areas of agreement. And it's thrilling, and I just can't wait to share it with you. And I want you to go online at constitutioncenter.org and check it out, and learn from it, and expand your constitutional knowledge. And what our gathering tonight is a wonderful follow-up to that exciting evening, because here we have gathered, and I say this without any exaggeration, the 4 greatest scholars of religious liberty in America. And they come from very different perspectives, and we were just in the green room, and I made the obvious joke about Jefferson dining alone, because this group is not usually convened in one place. And to make matters even better, several of them have contributed to the Interactive Constitution. And if you click on the First Amendment, you will find Michael McConnell and Marci Hamilton describing their areas of agreement and disagreement about the Free Exercise Clause and the Establishment Clause of the Constitution. And it is meet and appropriate that we summon them here today, because this is the beginning of World Families Week. The Pope will be on Independence Mall on Saturday, delivering an address at the podium from which Abraham Lincoln gave the Gettysburg Address. And to honor his visit to Philadelphia and to America, we've opened up a beautiful new exhibit on religious liberty and the American founding that Marci Hamilton helped us curate, along with Danielle Evans, our wonderful senior fellow for constitutional studies. Go downstairs after the show and see it. It's in the Annenberg lobby, and you'll see treasures of religious liberty, including one of the 2 signed copies of Washington's first Thanksgiving proclamation, where he gives thanks not for Thanksgiving, turkey, but for the Constitution, as well as Jefferson's letter calling for a wall of separation between church and state. What we need to talk about today, and we have a lot to learn from the people who know more about this than anyone else in America, is what the framers had in mind when they drafted the beautiful words of the First Amendment, which I will read once I introduce our panel, and what agreement and disagreement there is today about what they were trying to achieve. So with that completely narrative introduction, because I'm just telling you how exciting it is that we have these 4 scholars, please join me in welcoming our panelists. Marci Hamilton, Doug Laycock, Michael McConnell, and Philip Hamburger. I feel like a constitutional barker at times, a kind of talk show host, but for this particular group, it is really worthwhile, because I'm so honored to welcome them here today. And of course, just whet your appetite, after hearing from them, you're going to hear from 4 of the most thoughtful people in America about contemporary questions about religious freedom. But we're going to begin with history. And I wish so much that I had just hooked up the Interactive Constitution so I could display it behind you. But I want to begin with Michael McConnell and Marci Hamilton, who wrote about the Constitution, and they wrote about the Establishment Clause. And Michael, you have a common statement about the history of the Establishment Clause. I would have thought this was one of the most contested in all of constitutional history, but you wrote a common statement. How long did it take you to agree about the settled meaning of the Establishment Clause?
Oh, I'd say a couple weeks. Maybe actually, by the end, we had one major disagreement, which was over the role of Catholics in Maryland at the end of the 17th century. which is a pretty technical point. The reason it didn't take any longer is you only wanted 800 words, and so we could leave out all the contentious stuff.
And what was the disagreement about Catholics in Maryland?
I take what I think is the traditional view that Maryland was founded as actually the most free exercise friendly of all the early colonies. It was founded by a Catholic proprietor for the benefit of Catholics so that they would have a place where they would be able to go and be able to worship in peace, but extended also to others. And Marci has a somewhat more somber sense of the Catholic role.
Marci, what is your somber sense?
Well, I was looking more at the history of the conflicts between Catholics and Protestants that showed that the Catholics really did have some serious control. And I'm a real believer in a functional understanding of the Establishment Clause and the separation of church and state. So I didn't really care if they called themselves an establishment, but the discord was pretty ugly at times. But we agreed to start out the whole thing by saying that the United States was settled by Catholics and Protestants and Jews, and that was my main concern, that we made sure that we mentioned more than just the Protestants at the start.
And you did indeed. The first paragraph of this great explainer says, America's early settlers came from a variety of religious backgrounds. Puritans in New England, Anglicans in the South, Quakers and Lutherans flocked especially to Pennsylvania, Roman Catholics in Maryland. Presbyterians were the most numerous in the Middle Colony, and there were Jewish congregations in 5 cities. It's so clear, and several of the people who saw this on Friday said it's just a model for prose and for teaching school kids about English language arts as well. And I think David Coleman also wants to do that because this is written for citizens. It's not for lawyers. It's nuanced. It doesn't dumb anything down, but it is just thrilling to have all of this in one place. Okay, we have so much to talk about. I said I would read the Establishment Clause, even this interactive, this pocket constitution, which I never leave home without, with its thrilling introduction by yours truly and David Rubenstein, is now made almost obsolete.
Funny, I didn't even know you were around back then. You wrote the intro?
It was incredible. You know,
We the people?
It took a long time, but you know, it's a tough job. Someone's got to do it. You can now find that essay as well online. But we'll begin with the words of the First Amendment, which you know from reading our Bill of Rights. One of its 12 original copies was originally not the First Amendment, but the third. When you go to see the original Bill of Rights and also the first public printing downstairs in the Religious Liberty exhibit, the first article had to do with apportionment in Congress and said there had to be one representative for every 30,000 inhabitants. There'd be 4,000 Congress people if that had passed today. It was a coincidence that their Third Amendment became our first. And therefore, the famous language of the First Amendment, which says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, far from being at the top of mind, just became the First Amendment almost by coincidence. Philip, you have, you know, I haven't even I got so excited I haven't properly introduced our panelists, which I will just do in the briefest way as I call on them for the first time. Philip Hamburger is the Maurice and Hilda Friedman Professor of Law at Columbia Law School. Really, as I said, like his colleagues, the leading scholar in the country about the constitutional history of the First Amendment, and his most recent book is Administrative Law Unlawful? Let me begin with a hot-button question about establishment that always allows me to use an SAT word, which is anti-disestablishment. And there are some scholars, and I wonder if you're one of them, who say that the point of the First Amendment wasn't to prohibit any state endorsement of religion. It was to prevent the federal government from disestablishing state churches like Anglicanism in Virginia and the other ones that Michael and Marci write about. Is that anti-disestablishment interpretation convincing?
Right. It's a wonderfully clever interpretation of the First Amendment. One reads it and one thinks it's really about religious liberty and disestablishment. And then come along these academics who say, well, actually, it's cleverer than that. It's really just designed to protect state establishments, the very opposite, as it were, because it only seems to bar, perhaps it's jurisdictional, only seems to bar laws respecting establishment of religion, and that leaves room, of course, for the folks who had state establishments, as my home state, Connecticut, had an establishment until 1818, Massachusetts until 1830. If there's to be no law respecting an establishment of religion, that actually prevents federal laws, Congress from passing a law that would interfere in state establishments. And certainly, this makes it politically acceptable, I think, to the New England states, who many of them revered their establishments. But is that to say that it's merely jurisdictional, that it doesn't protect religious liberty? And I would emphatically disagree, as would, I think, most of the religious dissenters in early America. They thought they had won their religious liberty with the Establishment Clause.
Fascinating. Douglas Laycock is Robert E. Scott Distinguished Professor of Law, class of 1963, Research Professor in honor of Graham C. Lilly and Peter W. Lowe, and a Professor of Religious Studies at the University of Virginia School of Law. That is the coolest chair title I've ever heard. That is very impressive in its
Try to take
scope.
care of our donors.
Very nice. We should take a book from that. Do you agree with Philip?
Generally, yes. So plainly what the Protestant dissenters who successfully demanded an establishment clause wanted was no federal establishment. I think it's also equally clear it didn't enter anyone's mind that the federal government would disestablish or interfere with the state-established churches. No one thought they had power to do that. No one thought it was politically feasible to do that. So it wasn't going to happen. But the argument you raise carries us one step further and says, it's got this funny word, respecting, and it means concerning, done with respect to. Right? Any law with respect to an establishment of religion could include, literally, textually, a federal law interfering with the Massachusetts establishment. Philip's read a lot more of the original writings and so forth than I have, but I've read quite a bit. I've never seen anybody argue that or suggest that was what they were trying to accomplish. And here's a factoid. On that interpretation, if that's what it was about, to protect the state establishments, it was a particular favor for Massachusetts and Connecticut, who had the most fully developed establishments. They didn't ratify until 1939 on the 150th anniversary. If it was for them, they didn't want it.
Fascinating. Any takers for anti-disestablishment? Michael, do you think there's anything to it?
I don't think anti-disestablishment was the point, but there was an original version which did not say Congress shall make no law, and it did not say respecting an establishment. It was just there would be no establishment, and there was a debate in the first Congress where a representative from Connecticut points out that that language could have disrupted the Connecticut establishment, because if two people sued in federal court if somebody failed to pay their mandatory tithes to their church, which is the essence of the establishment, and then they were sued in federal court, that the federal court could say, no, the Constitution prohibits an establishment, and thus sort of indirectly through the courts destroy the establishment of Connecticut. And I think that that's the reason they added the words Congress shall make no law, and also the respecting came about, because the principal point was not to have a federal establishment, but they were concerned not to disrupt the state establishment at the same time.
Great. And I should say that Michael McConnell, in addition to being the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford and Senior Fellow at the Hoover Institution, is a former judge on the U.S. Court of Appeals for the 10th Circuit, where he served with great distinction. Marci, we have this wonderful religious liberty exhibit downstairs, and I need to give a shout out and a sincere thank you to Seth Kaller, who is here. He helped us assemble from the greatest document collectors and philanthropists in the country these precious treasures of religious liberty. They lent them generously and quickly, and thank you, Seth, for putting this wonderful exhibit together. Marci, you, first of all, let's remind you have an incredibly fancy and impressive title as well, and right now the bar is kind of high for endowed chairs, so yours is the Paul R. Verkuhl Chair in Public Law at the Benjamin M. Cardozo School of Law at Yeshiva University. You helped us curate that exhibit, and in the middle section of it, you can watch the evolution of the language that became the Establishment Clause. The House originally had said that they wanted to prohibit an establishment of religion, but the Senate had a softer version that said Congress shall not have any articles of faith. Was that a softer and less restrictive notion? And I gather the House pushed back and won, but what was the Senate trying to achieve with that language?
Well, there was a concept that was the basic premise of the entire debate, which was that the framing generation understood what a theocracy was like. And the concept was that they were trying to formulate a way not to have a national theocracy. But the truth of the matter is, and I think Leonard Levy does by far the best work on this in terms of the history of this, the Establishment Clause just planted a seed. And so that language, I honestly don't think either side fully understood the full import of the language. And we ended up with an Establishment Clause that only applied to Congress by words. But by 1833, there were no establishments left in the states. So it's my view that that debate is the seeds for the increasing disinterest even in the states for an establishment.
Or disestablishment.
Disinterest for establishment.
Michael, what were quintessential examples of establishment? You can see downstairs in the exhibit George Washington having to sign a test oath in order to serve as a member of the Virginia military. He had to forswear transubstantiation and other Catholic doctrines. And then William Penn, in a book printed by Benjamin Franklin, says that anyone who professes to believe in Jesus Christ can hold public office. That was a more liberal provision because you didn't have to be a member of the established church. Is that what they were worried about, or was it something else?
You need to look at the set of laws which established the church. So the church by law established in Britain was not one law, but essentially four. So there was the Supremacy Act, which gave the king or queen, the monarch, control over the church. That's government control over the church. This actually wasn't a theocracy. It was the opposite. It was government-controlled church rather than church-controlled government. So the Supremacy Act makes the monarch the head. The Uniformity Acts create a uniform set of liturgy, that's the Book of Common Prayer and the Articles of Faith of the Anglican Church. That's actually what the Senate was getting at when they said there will be no articles of faith or modes of worship, is they were essentially saying we'll have no uniformity acts, and all churches had to conform to those. So you could not have a public worship service other than in accordance with the liturgy and articles of faith of the Church of England until the Toleration Act, which allowed 4 Protestant denominations to deviate from portions of that. Then the third was the Test and Corporation Acts, which prohibited anyone from holding high office in the government or the military, and that included dons at Cambridge and Oxford, and this is what George Washington was swearing to. The Test Act required you to swear that you did not believe in the Roman Catholic doctrine of transubstantiation and that you had attended and received communion in the Church of England within the last 6 months. That means that no one can you can be an ordinary subject of the king in England without conforming to that, but the entire leadership of the country has to be part of the Church of England. And then finally, there were laws requiring religious tithes and attendance. So those are the 4 headings under which the Church of England was established. I think that the Establishment Clause prohibits all 4.
Great. So that is the core meaning, and there's agreement about if the government were to compel tithing, that would be an establishment. And the question we now have to explore is how much further the Establishment Clause goes. In the exhibit, we have a reproduction of Thomas Jefferson's famous letter to the Danbury Baptists calling for a separation, a wall of separation between church and state, and an original copy of his letter to a different group of Baptists talking about the protection of the rights of conscience as being among the triumphs of the Revolution. Philip, you have written an important and widely discussed book against separation in 2002, and you say, the standard claim on behalf of separation is that it was the religious liberty demanded by 18th century religious dissenters, But you say, in fact, American dissenters made demands for religious liberty that were different from separation, although the evangelical dissenters who dominated the campaign relied on numerous arguments. They tended to demand constitutional protections of two types: equal rights without respect to religious difference. More broadly, law should take no cognizance of religion, but you reject the idea that there was supposed to be a complete wall of separation. Tell us more about that.
I think we can begin with the text, and it's rather amusing to think about the overlap between the phrase separation of church and state and the phrase in the Constitution, Congress shall make no law respecting an establishment of religion. What's the overlap between these phrases? And I think it's that very important word "of." And once one realizes how little overlap there is, one can begin to explore this seriously. The dissenters in 18th century, the religious minorities in 18th century American states, many of them, in fact, most commonly demanded equal rights that would not be punished with respect to one's religion or non-discrimination. And the smaller number, and they were joined by Madison, said there should be no laws respecting religion. And what's interesting is the Establishment Clause in the First Amendment adopts neither of these provisions. It says no laws respecting an establishment of religion, which means it is okay to have laws regarding religion, which means that this is not simply an equality standard. In other words, one can have laws favoring religion. And what they certainly didn't do is talk about separation of church and state. Separation of church and state actually is popularized and becomes well known at this time, mostly not as a demand for religious liberty, but as an accusation. The establishment ministers who want to disparage dissenters asking for religious liberty, establishment ministers would say, we know what you really want. It's not religious liberty. You want a separation of church and state, separation of religion and politics, which is a way of saying, you dissenters, you're really against morals. You want to separate government from religion, which is the foundation of morals. So the real question is how this all got flipped around, and this became our interpretation of the First Amendment, and that's an interesting story.
I'll ask more about it in a sec, but I want to note a review of your book by Doug Laycock, The Many Meanings of Separation. Doug, you said Philip Hamburger shows conclusively that separation has a long and dishonorable tradition as a rationalization for Protestant suppression of Catholics and for attempted secular suppression of all organized religion. Hamburger surely errs, however, in taking this meaning for granted and imputing that meaning to everyone who invokes the same concept, but it seems undeniable that Hamburger's meaning of separation is one meaning. Amplify, please.
Well, part of the problem with separation of church and state is it is just a slogan, and different Americans have used it to mean radically different things. Even the Puritans believed in separation of church and state, but they meant institutional separation. Ministers couldn't hold elective office. The institutions of the state and the institution of the church were entirely different. Plenty of people were talking about keeping the church and state apart, keeping them separate, government taking no cognizance of religion, government is not a competent judge of religious truth, the dissenter said during the founding period. The phrase separation of church and state, I agree with Philip, didn't become widespread and popular until the anti-Catholic moves in the mid-19th century. So there's an honorable tradition of separating the religious activities and belief of the American people from the power of government. And you do that by not letting the church pick one religion and promote it, by not letting the church regulate religion, by not letting the state regulate religion, not letting the state interfere with the religious practices of the people except where it's necessary. Religious exemptions are a form of separation of church and state. And there was this rhetorical tradition from the middle of the 19th century up to the middle of the 20th, really, that was using church and state for a set of demands that was heavily anti-Catholic and for a smaller group, anti-religion in general. It's pretty clear that's never what the Supreme Court has meant when it talks about separation of church and state. It doesn't talk about it much anymore. But in the period from the end of World War II to the late 20th century, when the Supreme Court talked about separation of church and state, it understood separation as a way of ensuring government neutrality towards religion. I think that's an honorable tradition, but the problem is so many people have used the phrase in so many different ways, it doesn't really help much anymore.
Jeff, could I add something to that?
Please do.
I really don't think that it's possible to talk about the separation of church and state without giving a nod to the Baptists. The Baptists were the original group that actually came up with the idea that there would be such a separation. And the reason they needed to is because they were being oppressed by the established church, primarily in Massachusetts. So the concept is as much functional as it has these more text-based reasons. And I think that is the operative way to understand it. I also reviewed Philip's book, and my disagreement with Philip with respect to separation is that I disagree with the concept of anti-Catholicism as the basis for separation. It's anti-papism, which is a very interesting concept to have the week that the Pope is coming to Philadelphia. And if you read carefully the works of James Madison, there was an anti-clerical concern at the framing, and there was also a concern later in the 19th century, and the concern was whether or not Catholic citizens were going to have allegiance to the Pope, or they were going to have allegiance to the form of democratic government here in the United States. I disagree with the concept that it was just anti-Catholicism. I think it's a perfectly legitimate question to ask, and of course it was asked of JFK, and JFK answered it that he would be true to the laws of the United States and would not be controlled by the Pope. So that is something that needs to be part of the discourse. Anti-clericalism is actually part of the American history of understanding the control of religion, but also the freedom of religion.
Michael, I want you to chime in and also give a sense of what you think of Philip's thesis, and then of course Philip can respond.
First, that's what anti-Catholicism is in America, is the belief that Catholics cannot really be full citizens of this republic because of their allegiance to Rome. It's true it was a concern, and the concern goes by the name of anti-Catholicism. It's true that it was dispelled by John F. Kennedy, but that's the concern that he was addressing. So I don't see why we don't give it its name. Now, I don't entirely agree with Philip either. Philip, I think all four of us have a slightly different sense of this, but let me say what I think was at stake when Jefferson wrote his letter, because I believe that the concepts of forbidding establishment and forbidding interferences with free exercise are specifically addressed at the power of the state. These are things that the state does. These are types of laws that the state uses to regulate religious activity. The subtle change from no establishment to separation, when you think of separation, you're now thinking about both sides as if the First Amendment somehow requires religion to be separate from government. And I don't think that that is an accurate understanding at all, but I do think that that was Jefferson's political motive when he wrote that letter, because as you may know, that he was widely derided, especially in New England, because of supposed atheistic tendencies, and in particular, clergy in New England were quite vicious in their attacks on him. Anybody who thinks, by the way, that modern politics is somehow less negative and contumacious than the founding hasn't read much about the politics of the founding. So Jefferson was upset that these New England clergy were attacking him for being an atheist, and separation of church and state was his subtle way of sort of twisting the First Amendment in order to make it look as though there was something improper about that. And in fact, I think that there is nothing in our First Amendment tradition that forbids churches from being as involved in politics and as any other private organization. What the First Amendment is about is restricting the powers of the government with respect to religion. It's not restricting religious citizens with respect to their ability to try to influence public affairs.
Philip, I want you to respond to the scurrilous criticisms of all four of your colleagues. Of course, they're respectful, but in the course of doing that, help clarify for our audience what's at stake. On the modern Supreme Court, the strict separationists, and perhaps Justice Ginsburg would be a quintessential example of them, insist that the Establishment Clause requires neutrality between religion and irreligion, and another group of justices led by Justice Scalia say that the government has to be neutral among sects, but not between religion and irreligion. Is that the dispute that you're having, or is that a different one?
Yeah, so what's at stake here, and I think it's a good idea to step back a little bit from this, because it's not really about our scholarship. There's something very important, a high principle that we all have a stake in here. And the question is, should we look at the Constitution's words in the First Amendment and try to understand them as laying out a delicately drafted religious liberty? Or should we parse this, interpret it in terms of a popular slogan, in this case, separation of church and state, or you could add neutrality if you wish? And this has been a project that's been taken up by many. Some are anti-Catholic. The anti-Catholics, not least here in Philadelphia, popularized this in the 19th century. It's why a church about 2 blocks from here got burned down in some riots in 1844. But it's not just anti-Catholics. There are also many theological liberals who were worried about all church influence. And Thomas Jefferson was one of these, and the post-war Supreme Court sort of joins this crowd. But leaving aside this division between the anti-Catholics and the more generally anti-Christian, anti-church types, what's at stake here is, do we parse the First Amendment in terms of separation of church and state? And think about what's at stake here. The Establishment Clause is about Congress or government supporting religion, establishing religion. It's like a vertical metaphor, if you will. Separation of church and state can be understood more as a horizontal metaphor. It's about keeping these institutions apart. In other words, separation no longer simply limits Congress. It limits also religion. And that's not in the First Amendment. What's more, it discriminates amongst religions, because instead of saying separation of religion and state, it's about churches. It's about organized religion as a particular danger. And you can see why this lent itself to anti-Catholics. So this becomes a very discriminatory phrase that's used to parse what actually was a marvelously drafted piece of constitutional law.
Beautiful. Well,
If I could take one more sentence.
Please do.
The fundamental point of disagreement is that this was never the view of the Supreme Court in the middle of the 20th century or later. The theological liberals that Philip talks about, I agree, they were there, they were for real. They had 9 demands. They got none of them from the Supreme Court. Wasn't what the Supreme Court meant by separation of church and state.
I'm turning to my interactive constitution. So far, we've really been focusing on the Establishment Clause of the First Amendment, and we need now to turn to the Free Exercise Clause of the First Amendment, and we can do that by going to the interactive constitution and pressing the clauses and finding Fred Geddicks and Michael McConnell wrote about the Free Exercise Clause. Michael, tell us about how you and Fred came to agreement, and what did you agree about, and what did you disagree about?
We actually, I think it's fair to say what we agreed about is what is the current disagreement, because there's, if anything, more disagreement about the meaning of the Free Exercise Clause than the Establishment Clause, and but it's less complicated. There are essentially 2 views, a little oversimplification, but essentially 2 views. The First Amendment says Congress shall make no law prohibiting the free exercise of religion. I think everybody now agrees, although the Supreme Court for a very long time said the opposite, but everyone now agrees that exercise of religion means putting it into effect. That does not mean you can just believe what you want to believe. It means you can put your beliefs into effect. That's what exercise means. But one view says that the government does not violate that unless it singles out religion on a discriminatory basis and says, you can't do that because of its being religious. So for example, some zoning ordinances would allow you to have a meeting hall, but not a church. That would be singling out religion for a particular prohibition as a religious meeting rather than generally. And then, but that view says that if there's a law that applies across the board, that it doesn't violate the Free Exercise Clause. So if, for example, you had during Prohibition, if there had been a law that said no alcoholic beverages can be supplied, that could outlaw the Mass or the Jewish Seder or other sacraments that use wine, and that there would be, and the Free Exercise Clause under this first view would provide no protection for the exercise of religion against a neutral and generally applicable law. The other view is that the Free Exercise Clause is triggered whenever the exercise of religion is prohibited. That is to say, whether it's a neutral and generally applicable law doesn't matter. If it prohibits you from exercising your religion, then it is covered. Now, this presents another problem because it can't be covered absolutely. There are many things that people might want to do, might need to do from a religious conviction that can't be tolerated in a civil society, that do violence to others or disrupt the public good. And so under this view, you have to have some kind of implied limitation. What the Supreme Court has said is that's a compelling governmental interest. That's a notoriously slippery formulation that I doubt anybody up here particularly approves of. So the first view has the problem that it doesn't actually seem to protect religious exercise against, perfectly expectable problems. The second view has the problem of having to craft limits that are not in the text and that are very difficult to formulate.
Thank you for describing those two views so well. Those limits will be the subject of our next panel, in particular whether people should get exemptions from generally applicable anti-discrimination laws if they're religiously observant. Philip, I want to ask you more about the natural law history of the Free Exercise Clause. One of the thrilling things that the interactive Constitution does, in addition to uniting the finest scholars in America for agreement and disagreement, is allows students of the Constitution, that's you, to click on any provision of the Bill of Rights and see its historic antecedents. You can watch the language evolve from the Revolutionary era state constitutions, and thanks to Seth and Marci, you can see original documents of those drafts downstairs. The Virginia Declaration of Rights, and we have a rare printing downstairs, and you can see it online, was written by George Mason, inspired both Jefferson when he wrote the Declaration and Madison when he wrote the Bill of Rights, and talks about the unalienable rights of conscience, the people's unalienable right to worship God according to the dictates of conscience. Philip, what did it mean for the rights of conscience to be unalienable, and what is the significance of that for the free exercise debate?
Right, so this is actually one of the great achievements of early America. The First Amendment, like the Virginia Declaration of Rights already in 1776, treated religious liberty as an inalienable right, and that is an unconditional right, one that was not subject to any conditions or qualifications at all. This had not been true in England. In England, there had been merely toleration, which was a great achievement in the 17th century, but looked rather lame by the 18th. And toleration was a conditional liberty, such that the government could, if you didn't meet its conditions on your beliefs, interfere with your freedom on account of your religion. And this leads to questions about the debate that Michael was talking about, because if one's liberty is so broad that it's subject to qualification with a compelling government interest test, it's beginning to look rather conditional. And if I might step beyond just this one clause to think about all of our Bill of Rights, we have a structural problem in framing rights. One can draft a right narrowly enough that it's unconditional, that it's never qualified. Or you can draft it very broadly, but then you have to say, well, some instances you don't get it. And the framers of our Constitution, I think, as Madison actually carefully laid out in one of his letters, October 17, 1788 to Jefferson, explains you have to draft your Bill of Rights narrowly, have narrowly protected rights, because those will always be secure and there'll never be an excuse for violating them. And the danger of a broad religious liberty that is an exemption from general laws is that it will be qualified, it will be conditional, and that undermines, I think, the profound achievement we had in the 18th century.
Doug, say more about what it means to be an unalienable right. The framers believed that unalienable or natural rights came from God and not government, and when we moved from the state of nature to civil society, we couldn't surrender or alienate those rights to government, even if we wanted to. And as I understand it, conscience was an unalienable right because my religious beliefs or non-beliefs are the product of external sensations operating on my reason. And as creatures of the Enlightenment, the framers believed with the Scottish Enlightenment thinkers that our rational conclusions, our ability to reason, couldn't be alienated to government. What is the significance of that for the First Amendment today?
I'm not sure it has a whole lot of continuing significance. It is part of our continuing theory, political theory, that our rights are unalienable, that we can't give them back or surrender them to government. But that doesn't tell us how to interpret them as they are embedded in the Constitution and as they continue to exist. The Enlightenment thinkers you point to were one important strand in 18th century thought. The more numerous strand in terms of the religion clauses, the groups that delivered the political muscle to insist on a guarantee of religious liberty were the Protestant evangelicals in the 18th century. But they had a similar view that salvation was so important, every man and woman had to decide for himself or herself, and no one, certainly not government, could tell you what you were supposed to believe about religion. They were a much less religiously diverse society. They were about 99.5% Protestant, and there was much less regulation. Government was very small. And so the issue of religious exemptions for religiously motivated conduct didn't come up very often. When it did come up, they dealt with it case by case, and they generally granted exemptions. So Quakers didn't have to serve in the military. They didn't have to do alternative service or pay a substitute fee. They didn't have to swear oaths. Religious dissenters didn't have to pay the church tax in most places by the middle of the 18th century. And there were some other smaller exemptions. There were differences in detail of Jewish and Christian incest laws, and the Jewish community in Rhode Island got to live by their own laws and not by the Christian laws and so forth. So when shortly after, some of the colonies were tolerant from the beginning, some were not. So take as the colonies that were intolerant. Once Massachusetts and Connecticut decided that they would allow Quakers to live there, very shortly thereafter they decided Quakers get exemptions for their religious practices too, because otherwise saying you can live here but you can't practice your religion would have been illusory. So I think, they didn't have to debate it in the way we debate it, with a fundamental cultural disagreement about basic moral rules, but when the issue did arise, they treated religious liberty as including the right to actually practice your religion, and they wrote religious exercise into the Constitution.
Jeff, can I respond to that?
Please do.
Since I completely disagree with that account of history.
Excellent. Tell us why.
The concept that we had a 99.9% agreement because everyone was a Protestant is the kumbaya theory of the Constitution, and it's not accurate.
That's not what I said.
That is what you said.
No, I said they were all Protestants, so the issue of exemptions didn't arise very often because of that consensus.
That is not how the Quakers and the Baptists felt about it in Massachusetts, who were terribly persecuted. That's certainly not how the Quakers felt about it in Pennsylvania, where for a good period of time you had to be Quaker in order to serve in public office. Why? Because a Quaker was someone who had come to the true faith, but the Quakers believed that you couldn't force someone to the true faith. So you had to let them come to it, and so then you could only give public office to the ones that it came to. The wonderful achievement of the separation of church and state and the Establishment Clause was grounded in the very deep differences that people felt about other faiths. There was no concept of, oh, yes, we're all sharing the same faith and therefore we're going to have the same agreement. The reason there was less demand for accommodation is a combination of less regulation, but it's also the fact that at the time, during the framing generation, they fundamentally believed in the concept of too much liberty. In a number of the state constitutions, they used the phrase licentiousness. Some of the state constitutions still have the phrase that licentiousness is not protected as part of liberty, and at the time licentiousness meant too much liberty or inappropriate liberty. Most of the state constitutions limited free exercise for safety and for peace. So we've always had a concept of a built-in set of limitations that are needed for a peaceful society. And the reason we needed those limitations is in part because of the deep disagreements over faith. Those who came over here really didn't understand, they didn't bring with them a concept of separation, they didn't bring with them even the functional separation that Doug mentioned earlier. They came from a place of a theocracy, and then for many of them, they set up one over here. But over the course of time, the diversity of believers in the United States has been so pronounced to the point that now we have over 100,000 sects in the United States. It's the diversity that has led to the deep belief in disestablishment and in the inappropriateness of the government being in control. Now we have this deep diversity, and now we have many, many disputes about free exercise, but those disputes do not belong to the Constitution. Those disputes belong to federal laws like the Religious Freedom Restoration Act.
Jeff, can I just throw in 2 cents here?
Please.
Because I also disagree with Doug on this, much as I respect his learning. And I want to come in on this because we are sitting at the spot where there was a profound debate on precisely this issue of exemption. These questions weren't just resolved in ad hoc manner, one by one. In 1775, Quakers feared that they might have to fight for the United States against Britain. Many of them were Anglos, unlike the Mennonites, who are of German origin, were quite happy to see the Brits go under. And the Quakers, therefore, stood alone. And the Quakers were the leading sect demanding an exemption from general laws, asking to be free from law on account of their religious beliefs. And they protested at the State House, right here. And you know what happened in response? The entire member of the Revolutionary Committee and the Committee of Safety, all of the members of the legislature marched down Market Street in a giant parade and presented a counter memorial to the legislature protesting the disgraceful opinions, as though they thought, of the Quakers. In other words, the claim of a general freedom from law on account of your religion was very broadly discussed right here. And
then what did the Continental Congress do?
The Continental Congress, of course, allowed them to be free from fighting, but it did ask them to pay an equivalent. You don't just be free from fighting as nowadays. You have to actually pay for someone to take your place.
Well, actually, it's not quite what the Continental Congress did. What they did was that they exempted the Quakers from fighting and then called upon the Quakers to make that kind of contribution to the war effort that was consistent with their conscience, leaving it actually up to them to figure out what that would be. So it suggests to me that maybe the mob in Philadelphia and the considered judgment of the representatives of the people of the entire country were not on the same page.
I would beg to differ. Quaker meetings, especially the meetings of sufferings, have extensive records of the fines they paid for failing to pay what they considered war taxes and an equivalent.
This superb discussion.
The two of you were, Phil is talking about the Pennsylvania legislature and Michael's talking about the Continental Congress. But in our time we don't have a draft, but in my time we did, and when we had a draft, conscience objectors were exempted, but they had to perform alternative service, and everyone viewed that as an exemption and is worth fighting for. There were 3,000 reported cases in the federal courts during the Vietnam period, and that's what the Quakers got during the Revolution. They did not have to fight themselves. They did have to pay this fee to support a substitute.
This superb discussion answers an excellent question, which was how does the 1777 exile of the Philadelphia Quaker leaders to Virginia rank as a conflict over religious liberty? We need to have closing arguments because our next panel will begin soon. I'm going to ask each of you to sum up as crisply as you can. Try to do it in a paragraph, really. It's a challenge. The original meaning of the religion clauses of the First Amendment.
You know, I don't get 500 pages. I would encourage each of us to embrace the text and then look at the context. The text of the First Amendment makes quite clear that it is not offering a separation of church and state, which is actually a very restrictive and discriminatory principle. The text, moreover, of the Free Exercise Clause makes clear that it's not offering an exemption from law on account of your religion, because notice, if a law does bear down on anyone so far as to be prohibiting one's free exercise of religion, then Congress should not have made it in the first place, according to the First Amendment. So it actually precludes judicial exemptions. And then when ultimately, to back this up, needs to look at the history, and notwithstanding claims to the contrary, there is no denomination in this country demanding separation of church and state. And the only denomination seeking before 1791, and there is no denomination seeking a general right of exemption that's of any political significance other than the Quakers. And the Quakers lost that battle and continued to lose it well into the 1790s, as is evident from their records. So I think both text and context counsel for a moderate but valuable interpretation of the First Amendment.
Thanks so much for that, Philip. Michael.
I think maybe the biggest misconception of the Establishment Clause is that it was designed to build a secular society. We often hear that, and maybe the Free Exercise Clause protects people in the privacy of their homes, but the idea of disestablishment is we would have a more secular society. I think that that's a misconception in that I think that together what they were doing was they were disarming government in the field of religion and leaving whether it's going to be a secular society or a religious society or what kind of society it's going to be to the private acts of individuals and churches and institutions and whomever. That what this is it's a massive, it's a double-barreled deregulation of religion. Deregulation both in the sense of allowing people to exercise their religion, but also deregulation in the sense that we cannot use the levers of government power, including support, including financial power for the government to be able to control religion, and that it wasn't designed to create a secular society, it wasn't designed to create a religious society, it was designed to create a religiously free society, which would go whichever way. I love the Supreme Court decision and says that the American people the religion will be left, will flourish according to the zeal of their adherents and the attractiveness of their dogma.
Wonderful. Doug.
I basically agree with that. The two religion clauses are to keep government from interfering with religion, either by regulating it, penalizing it, suppressing it, or by trying to support it, because when government supports religion, it inevitably supports a particular form of religion. It interferes with the free growth and development of religion, and it effectively suppresses all the people with religious views different from the one that it is trying to support. The particular applications that were of significance in the late 18th century were those applications that were controversial among Protestants. So they fought over how to finance the church, and money directly to the religious functions of the church was maybe the central issue at the time. They fought over exemptions in the particular context where they had moral disagreements. What I said a few minutes ago was they didn't have many moral disagreements. But when they did have moral disagreements that impacted somebody's religious practice, they generally granted exemptions. They didn't grant everything the Quakers asked for. They wanted not to serve in the military and not to pay an equivalent. What they got was you don't have to serve in the military. Many of the issues in our time were not an issue in their time, right? We fight over prayer in schools. They didn't have schools, and they didn't have many non-Protestants. There weren't significant political forces that could raise those issues. But the principle that they committed to was government shouldn't interfere, and government should stay out of religious controversies.
Many thanks. Marci.
Well, I think both Mike and Doug are fundamentally mistaken along the following line. I think it is a mistake to think that the framing generation was only interested in the protection of religion and religious liberty and not fearful of it. Religion and the state are the two most authoritative structures of human existence, and they fundamentally understood that, and in many ways had a much more realistic assessment of the way in which religion operates in the public sphere than some today. There was a need for the Establishment Clause not just to protect religion, but also to protect the state. And that's one of the reasons we have the only portion of the main body of the Constitution that deals with religion says that there can be no religious test oath. On the one hand, that protects our public officials from having to say that they are one religion or another, but it also keeps any religious entity from claiming ownership of who our elected officials are. So, so long as we understand the balance between liberty and limitation, I think that we will stay on the road to what is a miracle, which is that we have over 100,000 sects, such diversity, but we have not had a religious war. And that alone is a testimony to the brilliance of the framers, and it is my view that is this concept that there is a separation between church and state that has made that work.
Ladies and gentlemen, you've just heard a constitutional conversation conducted at the highest level. Please take a 5-minute break, just a brief stretch, and we will come back for the second panel. Please join me in thanking 4 great scholars of religious liberty.